Mr. Parker, cross-examination, you were asked about August 17th when Cindy approached you about your gun. Who did Cindy tell that there was a gun in your house?
She said it to Jesse.
No further question, John.
No refresh, Your Honor.
Okay,
All right, at this time, I ask that our first witness be allowed to step down.
yes.
And we also would like to call Dr. Emerson Couples to the stand.
Mhm.
May I proceed, Your Honor?
You may.
Dr. Couples, would you please spell your name, or excuse me, state your name, spelling your last for the record.
My name is Dr. Emerson Couples, Couples.
How are you related to today's case, Dr. Couples?
I'm a psychologist who was retained by the parks to see whether there was any psychological issues that Jesse may have had that might have, should provide a reason why he pointed a gun at City Park.
Dr. Couples, do you have an educational background in psychology?
Yes, I received my bachelor's in psychology from Macalester College, and I also received my master's and my PhD from the University of Illinois. And in between earning my master's and PhD, I also completed a one-year internship in Washington, D.C., and I also did some postdoctoral work as well.
Do you have much experience practicing in the field of psychology?
Yes, for the past 10 years, I have been a professor of psychology at the University of Iowa. There, my teaching and research has focused on child psychopathy and psychology. I've also written 3 books, and I've also authored or co-authored 25 peer-reviewed articles on child psychology, psychopathy, or both. And two of my works have specifically focused on child psychology in children under the age of 16.
Dr. Couples, what facts and data did you review in preparing for today's case?
I use the Psychopathy Assessment Instrument Juvenile, or PAIJ, during my investigation. It rates 10 different categories and assigns a score of 2, 1, or 0 to each trait for a score of 0 to 20. 2 means that the trait always applies, 1 means that it sometimes applies, and 0 means that it never applies. And because the criteria and scoring are somewhat subjective, the score of 12 is needed to define someone as a psychopath.
Dr. Couples, did you review the pertinent case materials, witness affidavits?
Yes, I did.
Dr. Couples, what conclusions did you reach about Jesse Duran?
Through my investigation, I was able to give Jesse a 12 on the PAIJ, which is enough to rate him as a psychopath. The traits that he exhibited are gratuitous and or guiltless lying, vandalism, and cruelty to animals.
Dr. Couples, can you briefly explain what psychopathy is for the court?
Psychopathy affects about 1% of the population. However, it should not be understood that they are deranged or depressed. Their faculties are completely intact. They're supremely rational. It's just that they think completely differently from normal people.
Dr. Couples, what are the defining characteristics of a psychopath?
Some of the defining characteristics are a lack of remorse and an intense egocentrism.
Dr. Couples, are there any myths about psychopathy?
Yes. It should not be understood that they are crazy, like people with schizophrenia or paranoia. People with those disorders, they have trouble distinguishing between reality and what is imaginary, which influences how they think and live their lives. Psychopaths don't have that problem.
Dr. Couples, is it possible for a child to be a psychopath?
Yes, children as young as 5 have exhibited the characteristics of a psychopath.
Now, Dr. Couples, your report that you submitted to the court had 2 major themes, the first of which was egocentrism and thrill-seeking. Do psychopaths have a problem with authority?
Yes, they don't listen to authority figures much, if at all.
Did Jesse Duran have a problem with authority?
Yes, there were numerous instances where Jesse failed to respond to threats of punishment from authority figures.
Do psychopaths have a problem responding to threats of punishment?
Yes. Throughout the course of my investigation, there are a number of instances where Jesse was violent towards others and
Objection, Your Honor, improper character evidence.
Your Honor, if I may,
Yes.
there is available case law in this instance. According to the case, the estate of Hamilton v. Walton, a psychological condition that is being testified about is not character evidence. Instead, it should be treated in the same way as if a doctor was coming up to the stand and talking about a physical trait that would influence a person's ability to or not to commit a crime. Furthermore, in the case of Longstreet v. Floyd, they specifically reinforced this ruling when an expert psychologist is testifying, noting that whenever an expert psychologist testifies about someone's psychological condition, it is specifically not character evidence.
Your Honor, may I respond?
Yes.
They're allowed to go into the general characteristics. They're not allowed to go into the specific instances of this violence they're about to go into.
Your Honor, if I may.
Okay, we're not going to make this much longer, though.
Certainly, Your Honor. First of all, we haven't gotten to any specific instances, and furthermore, if we get to those, you also can allow the specific testimony in through an exception.
I'm going to overrule the objection. Let's proceed.
Dr. Couples, how did Jesse Duran respond to threats of punishment?
there's a little evidence to show that Jesse responded to threats of punishment.
Now, Dr. Couples, you also said that psychopaths are thrill seekers. Can you explain that a bit more?
Psychopaths are thrill seekers in a number of ways, whether it be gaining positions of power, making money, anything like that. Even violent psychopaths are only violent because that's the only way that they know how to get their thrills.
Did Jesse Duran exhibit any thrill-seeking behavior?
Yes, he did.
Could you explain it?
Yes. There was an instance where there's instances where Jesse would that other students brought up during the course of my investigation. For example, he would always like throw rocks at cars, and the one time.
Objection, Your Honor. This is improper character evidence. At this point, they're going into specific instances.
Your Honor, if I may, first of all, it is not specific character evidence. The rules of evidence specifically state that witnesses are allowed to go into otherwise inadmissible testimony. So even if this was character evidence, it would still be admissible. However, these specific instances of conduct are being used to back up a psychological evaluation. Therefore, in line with the rulings of Floyd v. Longstreet and the estate of Hamilton v. Walton, they're not inadmissible as character evidence.
Your Honor, may I respond?
Pardon?
May I respond, Your Honor?
Yes, but this is the last time.
No.
Last response of this interchange. Go ahead.
Your Honor, they're using this evidence to show action and conformity therewith. They're using this evidence of violent instances where Jesse is throwing rocks at cars to show action and conformity therewith, that because Jesse was throwing rocks at cars in the past, he is therefore a psychopath and therefore is capable of psychopathic behavior. And this, Your Honor, is against the rules of evidence under Rule 404.
I'm going to overrule the objection. You're going to have an opportunity to cross-examine the expert, and you can deal with that issue at that time.
Yes, Your Honor.
Thank you.
Dr. Couples, did Jesse Duran ever commit acts of vandalism?
Yes. Several students that I interviewed throughout the course of my investigation said that Jesse couldn't stop stealing stuff. And he also constantly threw rocks at moving cars. And there was even an instance where he had a mailbox with a baseball bat.
Now, Dr. Couples, you talked about how psychopaths are aggressive. Could you explain a psychopath's aggression a bit more specifically for the court?
Well, psychopaths show no remorse at all. So what that means is that they're able to commit acts of violence that others would find horrifying. They would just shoot someone just to watch them die.
Dr. Couples, Did Jesse Duran show a persistent aggressive streak?
Yes, he showed it. He was persistently aggressive.
Did you find any concrete evidence of this aggressive streak?
Yes, I did. Throughout the course of my investigation, there was an instance where Jesse was, like I said, he would constantly fight, hit, or kick other students.
If you recognize the document corroborating the instance, would you recognize the document that corroborates this instance?
I
Your Honor, permission to approach opposing counsel and the witness in charge of what has been previously marked Exhibit 9.
Okay, thank you.
Just gonna give one to the judge as well. Your Honor, would you like a copy?
No, thanks.
Let the record show that the witness has been presented with the notification of student discipline. Dr. Collins, do you recognize what I just put before you?
Yes, I did.
What is it?
This is the middle school report that shows that Jesse was indeed violent towards other students.
Did you have time to review its applications to today's case?
I did.
Is it a fair and accurate copy?
Yes, it is.
Your Honor, at this point, plaintiff moves to enter what has been previously marked as Exhibit 9 into evidence as P1.
Any objections?
Yes, Your Honor. This is actually hearsay, Your Honor. This is an out-of-court statement that is asserting a truth.
I may, Your Honor.
Who is the person who prepared this statement?
This would be the Fairview Middle School, Your Honor. But if I may,
What's your response to her objection?
under Rule 704 for the expert witnesses, they are allowed to rely on what would otherwise be inadmissible evidence, including hearsay, if they use that evidence to form their expert conclusions. Furthermore, there is a specific piece of case law, the Association of Tarot Readers v. Midlands, which specifically states that as long as this hearsay is being used to further the expert's conclusions and would be helpful to the jury, then it's allowed to be explicitly discussed.
Your Honor, may I respond?
Yes.
First of all, let's respond to the 704 that my opponent just mentioned. I believe he's referring to 703, which is the basis of an expert's opinion testimony. According to 703, he's referring to the reverse weighing test. First of all, I'd like to make note that in order to use a reverse weighing test, they're saying that this evidence is otherwise inadmissible. That this evidence would not come into evidence for any other reason than for the reverse weighing test. Now this brings me to the reverse weighing test. In order for them to use the reverse weighing test, it has to be substantially more probative to this expert's conclusions, meaning that the jury would not in any other way understand this expert's conclusions without looking at this piece of evidence. And Your Honor, that's simply not the case. The jury can understand that Jesse may have been a psychopath without looking at this piece of evidence that they're trying to bring into evidence.
Your Honor, at this point it might be helpful if Your Honor had a copy to review the instance.
I think you're right on hindsight. I would like to see it.
Your Honor, if I may presume that we're in constructive sidebar that the jury can't hear,
Right.
I'd like to note that this specific instance talks about a game of dodgeball in a school gym class. Now, 11-year-old children can occasionally become aggressive in gym class playing dodgeball. So, unless I can exact the specific facts that Jesse Duran punched, kicked, and bit another student while screaming, "You have to die," during a game of dodgeball, then the jury isn't going to be able to distinguish whether this is just a little bit of school roughhousing as opposed to the type of aggression that a normal 11-year-old girl wouldn't commit.
Your Honor, may I respond?
Okay, this is the last speech.
Your Honor, this witness has already told us everything that they're about to try to enter into evidence. So we do not need to have this document that is hearsay into evidence that's going to go back with the jury after the end of trial. It's not necessary. Again, this is not necessary for the jury to understand the conclusions of this witness.
This is not signed by a school official, or is it?
Your Honor, it comes with a seal from the Fairview Middle School. It's been assumed to be a reliable document from the Fairview Middle School.
I think I'm going to overrule the objection and allow this in, and you may cross-examine on it.
Dr. Collins, Could you please explain how this school report factored into your conclusions?
Yes. This report shows that Jesse was kicked, hit, and hit another student. This shows that Jesse was aggressive and violent in the way that psychopaths can be.
Did this report factor into your conclusions in any other way?
Yes. It also showed Jesse being aggressive towards 2 other students. This shows Jesse's persistent aggressive streak, and it also shows his lack of responding to threats of punishment, and as well as to receiving actual punishment.
Permission to retrieve the document from the witness?
Yes.
Now, Dr. Couples, how do psychopaths feel after they act aggressively?
They feel no remorse. Even after they have committed a horrible act, they're not empathetic at all.
Does that mean that psychopaths don't understand the implications of what they're doing?
Not at all. It should not be understood that psychopaths don't know what they're doing. For example, in lieu of today's case, it should not be understood that Jesse did not understand that he was putting Cindy in harm's way, or that he did not understand that he did indeed harm Cindy.
Dr. Couples, I'd like to move to the other focus of your report, that of manipulation. Could you explain how psychopaths are deceptive or manipulative?
Yes. Manipulation, along with an intense egocentrism and lack of empathy, are 3 of the defining characteristics of a psychopath. They can be very sincere-seeming. They can use a person's words and actions in their own best interests. They're also able to show remorse, even if it is able to be used in their own self-interest. And they're also excellent liars. Jesse exhibited both this deception and manipulation.
What do you mean by that?
During the course of my investigation, there's an instance where Jesse and another student were being watched by a babysitter at the other child's home. During Jesse's time there, Jesse tried to drown a cat in another thing in a toilet and then lie about it. These actions are consistent with those of psychopath.
Dr. Couples, how does Jesse Duran's manipulative and deceptive streak impact today's trial?
It should not, in terms of today's case, it should not be any of Jesse's statements that Jesse made as part of today's trial should not be taken at face value, including his confession. Like I said, psychopaths are very manipulative, so anything that they say or do should be taken with extreme skepticism. It should also not be assumed that any psychopath knows any of the common tales of a lie. Anything that they do say should be viewed as serving their own self-interest.
No further questions, Your Honor.
May I just interpose before we start? May you keep your voice up a little more? Since I'm 80 years old, I'm entitled to be hard of hearing, and I am, so I need a little help from your voice, okay?
Okay.
Thank you.
Cross, Your Honor.
Yes.
Hello, Dr. Couples. How are you doing today?
Review.
Good. I want to begin by talking about what you would normally do for one of your patients. If I were your patient, I would need to make an appointment with a receptionist, correct?
Yes, of course.
And then after I made the appointment, I would come in for a set amount of time, correct?
Yes.
I'd come in and I would sit on your couch in your office.
Yes.
Objection, Your Honor. The relevance of this, Dr. Couples was an expert hired to make a conclusion about one specific person who they had no direct contact with, not give therapy to a student, or excuse me, a child.
Your Honor,
Let's wait and see where it goes, okay? We can overrule the objection.
I would come in and I'd come into your office and you would speak with me.
Yes.
You would ask me a line of questions that's designed to determine whether or not I'm being credible.
Of course, yes.
That line of questioning would determine whether or not I'm lying to you.
Yes.
That line of questioning would allow you to see whether or not I'm trying to avoid certain questions that you're asking me.
Yes.
And it's only after speaking with me that you would determine what was wrong with me.
Yes. Along with my investigation, that's what I would do.
And after you spoke with me, sometimes you would speak with me multiple times.
Yes, of course, sometimes it would take more than one session.
That's right. Sometimes you would see me for months.
Yeah.
Even sometimes you see some of your patients for years on end.
Yes, if they need continued therapy and treatment, then yes.
That's not what you did in today's case, is it?
No, it wasn't.
Let's talk about what you did in today's case. You didn't get a chance to speak with Jesse, did you?
No, I was not allowed to contact Jesse Duran in any way.
You never spoke with Jesse?
I would like to, but again, I was not allowed to, so that did hamper my investigation.
You never got to ask Jesse a set of questions designed to determine if he's lying?
Again, I was not allowed to contact Jesse in any way, so.
You didn't get to meet with him face to face to see if he was avoiding some of those questions that you were asking, that you would ask a normal patient?
Objection, Your Honor. At this point, this has become cumulative. It's very clear that.
It's repetitive.
Yeah.
So if you're finished with that point, let's move on. I don't think you're gonna get him to change his answer by asking 10 times.
Yes, Your Honor. I want to move on, and I want to talk about the applicability of the test that you used in today's case. You used the PI-J test, correct?
That's correct.
The PI-J test is a test that you trust.
Yes, it is.
It's a test that professionals in your field sometimes use.
Yes, it has been extensively peer-reviewed, yes.
And that test was designed by scientists that were professionals, some of the best in your field.
Yes, of course.
That PI-J test was designed for children between the ages of 12 and 16.
That's correct.
Jesse was not 12 years old at the time of the incident.
No, he wasn't.
And Jesse was only 11 years old.
Yes.
So that test that you used, the PI-J test, it isn't as applicable, say, to Jesse's case.
You know, while it may not be exactly applicable to Jesse's situation, I also have a number of years of experience. So even though this particular test was did not perfectly suit Jesse, I was also able to rely on my years of experience in coming to my conclusions.
Some professionals in your field don't even agree that it's okay to diagnose children as a psychopath.
Yes, while there may be some issues as to whether children can be labeled as psychopath, children as young as 5 have exhibited the characteristics of a psychopath.
I understand, but I was simply asking whether or not it is that some professionals in your field say it's not applicable to say that children are psychopaths.
Yes, again, there is some debate, but children have exhibited those types of characteristics.
All right, now I want to talk about what you can't tell us in today's case. You can't tell us whether or not the incident in today's case was an accident.
No.
You can't tell us if Jesse accidentally discharged that weapon.
No, I did not observe the incidents. No.
You can't tell us Jesse's intent at all for today's case.
No, not for certain, no.
No further questions.
Thank you.
Your Honor, I ask my witness to be excused from the stand.
Okay, are we ready to proceed?
Your Honor, the plaintiff calls Jules Sebastian to the stand. Can you please state your name, spell, and last name for the record?
Jules Sebastian, Sebastian.
And how did you become involved in today's case, Ms. Sebastian?
I received a call from Officer Dale Williams saying that he was in need of a forensic investigator.
Could you raise your voice a little?
I'm sorry. I received a call from Officer Dale Williams saying that he was in need of a forensic investigator at the crime scene on the day of Sidney Park's death.
And how long have you been a forensic investigator?
I've been the lead forensic investigator for Breckenridge County since 2010. And prior to that, I served as the assistant forensic investigator for 12 years.
And what's been your experience during your 16-year career?
I have conducted 212 previous crime scene investigations. During those investigations, I trained extensively in crime scene analysis such as ballistics, blood spatter analysis, crime evidence collection and preservation, and wound orientation. I've become so well equipped in these areas that I teach classes at the Midland State Police Academy in forensic science.
Ms. Sebastian, what kind of education have you received?
I received my undergraduate degree in criminology from the University of North Carolina, Charlotte, and my master's degree in forensic science from John Jay College. And I also received training from the Midland State Police Academy, where I finished second in my class of 331.
Pursuant to today's case, did you use any facts and data?
Yes, I used several different methods of crime scene analysis, including ballistics, fingerprint analysis, blood spatter analysis, wound orientation, and evidence collection and preservation.
And did you use any affidavits or any of the physical evidence from the crime scene by using those principles?
Yes, I utilized the autopsy report and the fingerprints from Terry Chapin, Jesse Duran, Andy Park, and Sydney Park. I also collected the clothes that Sydney and Jesse were wearing at the time of the shooting. And I also took photographs of the crime scene before and after.
And all the principles and procedures you use are widely recognized in your field as valid?
Yes, all of the methods that I use are widely accepted.
Ms. Sebastian, what is your conclusion in regards to today's case?
I have three conclusions in regards to today's case. One, that only Jesse Duran's fingerprints were found on the bullet. Two, that Sydney Park was turning rapidly toward the barrel of the gun at the time that the gun was fired. And three, that Jesse Duran's right hand was extended nearly fully when the gun was shot.
Let's start with that first point. What exactly does fingerprint analysis consist of?
Well, fingerprint analysis consists of identifying two samples. Fingerprint analysis consists of identifying points of similarity between two samples, a known and an unknown sample. Usually, I prefer 16 points of similarity to declare two samples a match, but that is not always necessary to declare two samples a match.
And did you use this test on the weapon found at the crime scene?
Yes, I fingerprinted both the weapon and the the shell casing.
And what were the results from that fingerprint analysis?
I lifted 4 prints from the gun. Although I couldn't get prints from the grip of the gun because it had a tacky surface, I was still able to lift 4 other prints. One belonged to Sydney Park on the barrel, another to Andy Park near the grip, and 2 to Jesse Duran. 1 on the barrel and 1 near the grip.
And did you find Jesse Duran's prints anywhere else in the crime scene?
Yes. After my analysis of the safe, I found Jesse Duran's fingerprints on the keypad of the safe, and I also found them on the shell casing.
And can you say with professional certainty that the prints on the shell casing were in fact Jesse Duran's?
Yes, although the prints were not a 16-point match as I prefer, the prints still showed a 12-point match, and none of the other people that I fingerprinted were consistent, so they were ruled out.
Let's move on to your second point. How were Jesse and Sydney positioned leading up to the accident?
Well, when I entered the living room, the young girl was laying in a west to east orientation between the coffee table and the couch. And so Sydney would have been sitting to the left of the couch, and Jesse would have been sitting 6 feet away from Sydney in the brown chair. In the moments leading up to her death, Sydney would have been turning rapidly toward Jesse, toward the barrel of the gun, when the gun went off.
Did you perform any other analysis or tests relating to your conclusions?
Yes, I considered the wound orientation and the blood spatter analysis.
And what did the wound orientation show?
Well, instead of the wound being a circular shape, it was an oval shape. And this showed that Sydney was turning rapidly at the moments leading up to her death.
Let's get into your third point, the gunshot residue. What exactly is gunshot residue?
Gunshot residue, well, when a gun is shot, tiny particles of GSR, gunshot residue, are expelled from the barrel of the gun. In this residue are heavy metal particles, and the metal particles get on areas close to the, in a close proximity to where the gun was shot, like the clothing, the tables, anything in the area. And
Did you find Jesse Duran, any gunshot residue on Jesse Duran?
oh yes, I found over 200 particles of gunshot residue on Jesse Duran's right hand.
And what does that indicate?
It indicates
No further questions.
MC?
Thank you. How are you doing, Ms. Sebastian?
I'm well, how are you?
Pretty good. I have a few questions about that gunshot residue test you were telling us about earlier. But first, I want to make sure the jury knows what gunshot residue is. If I were to have a gun in my hand and it went off, I would get covered in a fine metal powder, right?
That's correct.
And that metal powder is called gunshot residue.
That's correct.
And firing a weapon or having a weapon go off near you isn't the only way to get gunshot residue on my body.
No, it's not.
One of the ways I can get gunshot residue on my hand or on my clothing is by interacting with a police officer.
Yes, you can if the police officer has shot a gun or has come in contact with gunshot residue.
Well, actually, pretty much all police officers have high amounts of gunshot residue on their bodies, just by the nature of their profession. Would you find that to be an accurate statement?
Yes, that's accurate.
And that's just because on a daily basis, officers handle their guns, they train often, they clean their guns. It just comes with being, it's part of the job.
That's correct.
And I want to talk about how that applies to today's case. Now, you arrived at the scene at 10:23 a.m.
Yes, I did.
But actually, before you had arrived at the scene, officers had been there before you.
Yes, they did.
And they would have entered the living room and seen two children.
Objection, Your Honor. Speculation. The witness does not know what the officers saw when they entered the living room.
I think the fact is we don't have any officers here to my knowledge, and they're the only ones who know what they saw. So I'm going to sustain the objection.
Yes, Your Honor. Well, Ms. Sebastian, when you arrived at the scene, you saw Jesse Duran sitting at the dining room table, correct?
Yes, I did.
And you also saw an officer sitting right next to Jesse.
Yes, I did.
And you would say, to be fair, that that officer was in close proximity to Jesse.
Fairly close, yes.
And just like all other officers, this officer had high amounts of gunshot residue on his or her body.
Objection, Your Honor. Speculation. We do not know if that officer had been firing a gun in the recent past.
Your Honor, may I respond?
Go ahead.
Ms. Sebastian, in her own report, says that all officers have high amounts of gunshot residue on their body by the nature of their profession. It's Ms. Sebastian's own words.
If I may, Your Honor, that report indicated, well, A, that report was an out-of-court statement, cannot be used for truth in the matter at hand. But either way, the report stated that some officers in the back seats of the car where victims often have gunshot residue might have it. However, it did not say the specific officer sitting at that table had gunshot residue. We cannot be certain.
This is a side issue, gentlemen, and I don't think you're going to get much traction trying to pursue it. So why don't we move on?
Yes, Your Honor. You cannot tell us if that officer changed the concentrations of gunshot residue on Jesse Duran.
No, I cannot, but I found over 200 particles of gunshot residue on Jesse Duran's right hand. And so to that high of a degree, it would be unlikely for it to be transferred.
Actually, I want to talk about that. When you got to the scene, Sydney Park's hands were bagged.
Yes, they were.
And that was to preserve the concentration of gunshot residue on her hands.
Her fingerprints.
To preserve the concentration of gunshot residue on her hands and fingerprints.
But there was no gunshot residue found on Sydney Park's finger.
You tested Sydney Park's hands, correct?
Yes,
For
I did.
gunshot residue.
Yes, I did.
And you found no gunshot residue on Sydney Park's hands.
No, I only found gunshot residue on Jesse Duran's right hand, his shirt, and the coffee table.
And part of the reason you couldn't find any gunshot residue on Sydney Park's hands is because her hands were bagged at the scene, correct?
Not necessarily.
Well, her hands were isolated and prevented from contamination at the scene of the crime.
But when the gun went off, she could have gotten gunshot residue powder on her, so she would not be like glued up.
All right, well, Jesse Duran's hands were not bagged at the scene of the crime.
No, they were not.
And so the concentration of gunshot residue on Jesse Duran's hands might have changed before you tested Jesse.
That's a possibility.
And I also want to talk about that fingerprint testing that you did. you actually found Sydney Park's fingerprints on the safe at the Park Zone.
That's true.
You also found Sydney Park's fingerprints on the gun at the Park Zone.
Yes, that's true.
And you also found prints matching Jesse on that gun, correct?
Correct.
Let's talk about those. You found a print on the barrel of the gun,
In the barrel, yes.
and you also found a print matching Jesse near the grip of the gun.
That is correct.
Right? And both of those findings might be consistent with someone accidentally or playing with the gun.
Could be.
No further questions.
No redirect, Your Honor. I just asked that my witness be allowed to step down.
All right.
Your Honor, with that, the plaintiff rests their case in chief, and we just ask for a brief recess.
All right. I think we're doing pretty well on time. It's just after 4 o'clock. Let's take 5 minutes. Will that refresh everybody?
Yes, Your Honor.
Okay, thank you. Well, I don't think my grades are gonna get much more thorough. I've been doing too much talking. But they've settled down, they aren't doing too much more. Do you notice a real difference in quality, more or less, between your morning and afternoon? Yeah. The head of this group seems very good. She's pretty good, yeah. But the team is spotty. I mean, that seems a little bit shy of the tire. We'll see.
Both these teams seem better prepared than the one team.
Yeah.
How long have you judged this competition?
I've actually been a judge here maybe 3 or 4 times, which is unusual for me because I don't normally stay on one track. But I felt this was a well-run operation, as you would expect, and it had good students, and they deserved to get anyone they could. And I know how tough it must be to get presiding judges, and I said, what the hell, I'll just do it for 2 full days and give them a judge. And it doesn't look as if they have any extras.
No, I don't think so.
I don't think they're scratching. They probably were out shaking everybody by the back of the neck last night. But it'd be very, very unfortunate if these kids all worked as hard as they have and couldn't get a judge.
I helped to run our court competition in law school, so I know how difficult
Okay.
it is to get
Yeah,
judges sometimes, especially for earlier rounds.
and are you a trial lawyer now?
Mhm.
Good for you.
Well, I will be once I finally have a
Why don't you
license.
go?
Paperwork is still, in the mail.
I have the opposite problem. I would love to get a license in Florida
Mm.
where I am licensed, but I've never practiced down there. And the problem is I have to take the exam,
Mhm.
so I'm not
We have a
sure.
firm in Florida, and that's what all the people who transfer
Yeah.
down there say.
Did they say it's hard?
Like with any bar exam,
Yeah.
you get mixed opinions.
Everyone thinks it's easy if they hear they passed.
I mean, I know one of our partners passed Florida but did not pass New Jersey.
Oh, really?
And I thought New Jersey was very easy. So you
Wow.
never know.
I think I'm gonna try to do my practicing out of Pennsylvania, but I don't think I'm gonna have an immediate need for it. I just don't, we have an office in Boca Raton, which is close to where they are. But then I would have to pass the exam. I'm gonna get some help from those guys down there, see if they can give me an old bar review course.
What type of law did you primarily practice?
I did everything. I mean, I was doing it for so long, I got into everything.
Did you have a favorite?
I particularly enjoyed architects and engineers, legal liability. I'm sort of an amateur architect. And the case that I worked the hardest on, and we won big time, was the tobacco case, where we were up against the National Defense Council. And we were the plaintiff's counsel for Pennsylvania. And we got $13 billion. So that was really nice. I wasn't sure I heard people the first time.
I'm sure. Wait a second, what? How many zeros? That's awesome.
Everyone may please sit down. You don't take lessons easily. Now we're going to probably have a short recess at the conclusion of the testimony before you each present your closing statements. And depending on how much time we have left, we'll see how that goes. So if you are ready for the defense, let us proceed.
Your Honor, defense calls Terry Chapin.
If you don't have a preference, would you mind sitting over there? Do you have a strong voice?
I do, I think so.
Okay, that's fine.
Okay.
I just wanted to hear you say, I do.
Good afternoon, Mr. Chapin. How are you?
Hello, I'm fine, thanks.
Could you please introduce yourself to the court?
Sure. Hello, folks. My name is Terry Chapin.
Now, how are you involved in today's case?
Well, I live in Fairview here, and I was the next door neighbor of Sydney. Sadly, I actually saw her the day that she died. I was the one who called 911.
Before we get to that, I want the jury to know more about you. What do you do for a living?
I'm a motivational speaker. I traveled around the world as a missionary to underprivileged cities in America, but also internationally, just trying to spread the word of God and to just help battle global poverty. So I'm rarely actually at home, but I saw Sydney and Jesse on the street sometimes.
And you actually said that you were a neighbor to Sydney and Jesse.
That's right.
You see their families often?
Yeah, when I was home, I'd say I'd see them about every time. I didn't really interact with them all too often because I traveled so much, but when I did see them, they seemed to be best friends, just two little girls playing.
What about the summer of 2010? Did you see the kids often then?
Oh yeah, it was a pretty hot summer, so the girls were playing in the front yard with the sprinklers or sometimes some water guns. Just looked like they were having a good time.
Now I want to talk about the event in question for today. I want to talk about the night before August 17th.
Okay.
What were you doing that night?
I was actually traveling back from Asia. I just was doing a missionary trip and was returning home. So I tried my best to get back on the U.S. time schedule, had a few drinks on the plane, and tried to get some sleep before starting the next day.
And that day was August 18th. How did that morning start for you?
Started fine, I guess. I was actually jolted awake by a gunshot. Went off a little before 10 o'clock that morning. It surprised me so much that I actually got out of bed, put some shorts on, and just checked my next door neighbor's, the Parks house, just to make sure everything was okay.
What did you see?
Well, I first went to go look through the window because, I mean, I don't know. I was kind of worried because it sounded like a gunshot. I didn't want to, I didn't want to go in the house and if anything was wrong. So I looked through the window and that's when I saw her. I saw little Sydney on the ground. It was pretty awful.
What did you do?
Well, I don't know. I didn't know if she was, still alive. So I wanted to get into the house, but I was also scared because I didn't know if there was like an intruder or something. So first thing I did was I called 911. I told them someone needs to get to 23 Maple Street as soon as possible, and that's when I went through the front door and tried to help Sydney.
What did you see?
She was still the same way I saw her through the window. There's a lot of blood. It's kind of awful, but I was going to go check on her to see if she was still breathing, but that's when I kind of heard some noise behind me, and I turned around to see Jessie, her friend.
Did you say anything to Jesse?
Yeah, I wanted to make sure that there wasn't an intruder in there, so I said, "Are you alone?" and made sure that there wasn't a, burglar or something.
How did Jesse appear to you?
Really quiet. The only way I could really describe it is kind of in a state of shock. I knew the young girls were friends, and so that's really the way I could only explain it at first. But once I started talking to her, she definitely changed.
How did she change?
Well, once I asked, what happened, that's when, the poor little girl just started, shaking. I kind of saw her eyes swell up, and she just started sobbing. I felt terrible. I didn't know what happened, so I tried to comfort her as best I could. And that's when I started hearing the sirens, They were off in the distance, I guess, just making their way to us. So I waited for the police to arrive.
Did Jesse appear angry or hostile towards you in any way?
No, not at all. She was a little girl. She just seemed terrified.
Did Jesse say anything to you when you started speaking?
Yeah, we exchanged a little bit, but I don't know. I mean, nothing really concerned me. It just was asking her and just trying to make sure she was all right.
No further questions.
Can I proceed, Your Honor?
Mr. Chapman, I want to talk to you about the day of August 18th, 2010.
All right.
Now, that morning, you were lying in bed when you heard a loud bang, right?
I was sleeping.
And this woke you up.
It did, yeah.
You looked at your phone.
That's right. It was 9:45.
You just really wanted to go back to bed.
Yeah, man, I was jet lagged for sure. I wanted to get back on U.S. time schedule.
But you thought you should check out on that loud bang you heard, right?
Sure.
So you got out of bed, right?
I did, yeah.
You splashed water in your face.
Yep, and threw my gym shorts on.
You also popped a few Advil.
Yeah, I had a little bit of a headache.
You popped a few Advil because you were fighting a vicious hangover. Isn't that true?
Yeah, on the plane I had a few too many vodka Red Bulls to try to stay awake. I'll admit it.
So let's talk about when you arrived at the Parks house. So you then went to Andy and Lee Parks' house, right?
Yeah.
And at this point, you looked in and then you saw a young girl lying there, right?
Yeah, that was Sydney, yeah. That's what I saw first.
She was lying in a pool of blood.
Yeah, it was pretty bad.
So naturally, you called 911, right?
That's right.
And when you called 911, you explained what you were seeing before your eyes, right?
I just said send someone here right away.
But the 911 operator asked you, are you sure? Because you sound intoxicated. Isn't that true?
Objection, Your Honor. You were safe.
Your Honor, if I may, under Rule 803.1, this is admissible as it is a present sentence impression.
All right.
May I respond, Your Honor?
Go ahead.
Your Honor, this was a phone call, and a 911 operator's present sense impression could be impacted by the quality of the phone call, any residual noise. The only way to really get the statement in would be to have the 911 operator here to say what she or he
Do you
actually
really
thought.
think we need the 911 operator? Do you think she's gonna remember this call?
Probably not, in which case we wouldn't be able to get that statement on the record. But I would say that her present sense impression was impaired by the fact that this was a phone call.
I think we're gonna allow it. Objection overruled.
I'll ask a question.
Sure.
So after explaining what you're seeing before your eyes, the phone operator asked, "Are you sure you sound intoxicated?"
Yeah, she asked it and I said yes, send someone over and hung up the phone.
Okay. So Mr. Chapman, then you went into the Park Zone next, right?
That's right.
And at this point, you thought there was someone else in the house.
Right, so I wanted to check Sydney first, but just to make sure there wasn't a robber or something.
And this other person turned out to be Jesse Duran, right?
That's right.
And when you saw Jesse, Jesse's face was blank, as you say, right?
Yeah, she looked shocked, sure.
She was cold.
Yeah, I didn't really notice any sort of expression at first. That's how I really observed it.
Her face looked expressionless, right?
Yeah, I just said it, yeah.
No further questions, Your Honor.
No recross. May Mr. Chapman step down?
Yes. Thank you.
Yeah, you're welcome.
All right.
The defense calls Dr. DeRosa to the stand. Hello, Dr. DeRosa. Can you introduce yourself?
Well, hi, my name's Dr. Ashley DeRosa.
What do you do for a living, Dr. DeRosa?
Well, I'm a professor at Midland State University. I teach public health and policy there.
Why are you here today, Dr. DeRosa?
Well, I was asked to come to a conclusion about the events of August 18th.
Before we get into those conclusions, I want to talk about your expertise. What type of expert are you?
My research focuses on gun safety policy. I myself am an epidemiologist, which means that I study the nature of causality. And basically, what I did in today's case is I looked at the different factors that were in place on August 18th, and I determined whether or not it was possible that an accident actually occurred, and that was what caused Sydney Park's death.
I want to talk about your education. Where did you go to school at, Dr. DeRosa?
Well, I got my master's from Tufts University. I went and got my PhD from Midland State University, which is where I now teach. And in school, I studied public health policy.
Now I want to talk about today's case. In general, what type of methods do you apply to for cases like today?
Well, I begin by collecting all of the relevant information. I look at any sort of statements that I can get my hands on, and I kind of recreate a picture of what happened during the event in question. Then what I do is I start to work backwards in time. And as I work backwards, I consider the different causal factors that were introduced into the situation, and I determine whether or not they had an influence on what actually happened.
What type of evidence did you have for today's case?
Well, I looked at various affidavits from the different parties, affidavits that were prepared for court. I read Miss Hailey Duran's affidavit as well as Andy Park's affidavit.
Was that evidence sufficient to come to your conclusion?
It was.
Were those methods that you mentioned earlier, those the methods relied upon by professionals in your field?
They are, yes.
And did you sufficiently apply those methods to the evidence that we just got done talking about?
I did.
All right, now I want to talk about what conclusion you have for today's case. Well, what conclusion did you come to?
I was able to determine that the events of August 18th are entirely consistent with an accident inside the Park's home.
What do you mean it's consistent with an accident?
Well, in order to talk more about that, I kind of have to back up. So, the Parks bought a gun a year before the accident. By bringing that gun into their home, they introduced a risk factor. Whenever there's a gun inside a home, there's always a certain risk that an accident is going to happen. In fact, having a gun in the home can increase the risk of homicide as well as suicide within that household. But the biggest risk that is introduced whenever a gun is brought into the home is that of accidental discharge.
I know earlier, whenever you talked about this in my office, you showed me a diagram. Do you think it'd be helpful for the court to see a diagram today?
Absolutely. What?
Your Honor, may I set up a demonstrative?
Yes.
And Dr. DeRosa, the diagram that I'm looking at today, exactly what am I looking at?
Would you like me to go stand up and help you with that?
Your Honor, may the witness step down?
Whatever you want.
I
Well, what am I looking at when I'm looking at this diagram that you showed me earlier?
Well, I just sat down and made a quick list of all of the different ways that an accident could reasonably have happened in the park's home on August 18th. You see, accidental discharge is actually very common whenever you have children involved in a situation with a gun. In the United States since 2000, it's been shown that accidental discharges cause almost 600 fatalities and 16,000 non-fatal accidents every year. And those risks are severely exacerbated when you've got children playing with a gun.
But why is it that that risk is exacerbated whenever children are involved?
Well, children typically don't have the necessary training to understand how to operate a gun safely. Adults, it frequently takes us a day or more to receive gun safety training that's considered sufficient to operate with a gun safely. That's why gun safety training courses are typically several hours and span a couple days. But with children, it's almost impossible to really teach them everything that they need to know about how to handle a gun safely.
How prevalent was that risk in the park's home?
Well, the parks definitely had a daughter who was 11 years old, and Jessie Duran, who was also 11, who was playing at their home regularly.
Mr. Rand, you may go ahead and take a seat. How might exactly an accident occur with a child?
Well, I listed some of the different ways that it might occur up on that chart. For example, there's always a risk in a situation in which a child either stumbles or falls or has some sort of surprising act that occurs to them. It's very common if they're holding a gun to clench their fingers. If their fingers are anywhere near the trigger, it's very possible that the trigger could become compressed and that gun could go off.
Is there any other ways in which a child might accidentally discharge a gun?
Sure, apart from stumbling or falling or being startled and pulling the trigger, an accidental discharge could occur if a child doesn't know that there's a bullet inside the gun. There are numerous ways in which this could happen. Children often, like I said, don't understand all of the different ways that guns work. So it's very common for children to not know that what they're holding is a loaded gun and that there is the potential for it to fire.
When looking at the evidence for today's case, did you find any indication that Sydney may have known how to operate a gun?
I did not find any sort of indication that either Sydney or Jessie had any training with guns, either with guns in general or with the park's specific firearm.
No further questions, Your Honor.
May I proceed, Your Honor?
Yes.
Mr. Rose.
Hi.
Now, this is your first time testifying for someone who is not the victim of a gun-related accident, isn't it?
Yes, you're right.
And most of your research has focused on gun-related accidents in the home, hasn't it?
It has. Most of my research does deal with gun safety within homes.
In fact, one of your research is actually named Keeping Your Family Safe, isn't it?
Absolutely.
And before today, you haven't branched into any other areas besides specifically when children come over and get hurt by someone else's gun, isn't that correct?
Well, you're absolutely right. My field of study is gun safety within the home, and that is what I research on and write on.
But you specifically chose this case because it was able to send a message about gun safety, didn't you?
I certainly think that the more we as a community talk about how we can keep our guns safe, the safer our homes and our children will be. So yes, I'd like to start a dialogue about that.
But specifically in this case, you chose to testify because the victim was of the gun owners, didn't you?
There are numerous reasons why I'm testifying in today's case, but I can certainly agree with you that I think it's valuable that we start to have discussions about how we can keep our guns safely.
But initially, you didn't want to have that discussion, did you? It was only after an hour-long meeting with Hailey and Duran that you decided that you wanted to have that discussion.
Of course, you're absolutely right. I had a consultation with Hailey and Duran, and we talked about the specifics of the case. And once I heard what the case was about, that's when I decided that I would do my research and come to testify.
Let's be clear, Mr. Rosa. You did not review any of the affidavits or any of the material facts of the case during that hour, did you?
No, I was just briefed about the case by Hailey and Duran. It's everything that he told me in that case came directly from affidavits, which I later reviewed, though.
But during that meeting, you were torn, weren't you?
Of course, I always take the decision to take on a new case very seriously. My time is very valuable, and I like to spend it in the classroom teaching my students. So if I'm going to take on a responsibility like this, I want to know what I'm getting myself into.
And during that hour-long conversation, in which you didn't review any of the material facts, Hailey and Duran offered to double your pay, didn't he?
Yes, I articulated to him that I was pretty bogged down with the classes that I'm teaching right now. And after we talked about the facts of today's case, he did say that he would double my pay.
So you only agreed to testify after you realized that this would extend your cause and you were offered double the money.
Sure.
Now, you do get paid by Hailey and Duran for your testimony here, don't you?
Yes, I am an expert witness.
And you get $5,000 for testifying in court today, don't you?
Yes, that's for my travel expenses to come here.
And you get $500 an hour?
I do, yes.
And you work 75 hours in this case.
I did.
So that's $42,500 to testify for the Durans, isn't that right?
Yes, I'm compensated for my time. I would have been paid about that much for the work I do with my students.
Now, Mr. Rosa, you said that you examined the safe, isn't that correct?
Yes, I did.
And you said that there were ways to mitigate the risk associated with firearms, right?
That's true. There are certain ways to mitigate those risks.
And one of those ways is by buying a top-of-the-line safe, isn't it?
It is, yes.
And would you agree that the Gallucci safe purchased by the Parks was top of the line?
It absolutely was, yes.
And the safe was kept in good working condition?
It certainly was, yes.
And the safe was able to hold the gun without other people getting to it in normal operation, correct?
Sir, you're absolutely right, yes.
Now, you would also agree that the children were only able to ascertain where the weapon. That the children were only able to ascertain where the safe was while it was in the bedroom, correct?
I'm sorry. I'm not sure I understand the question. Could you-
I'll rephrase. I apologize. The safe was in the bedroom, right?
Yes, it was.
And you stated that that was a reasonable location
You're absolutely right, yes.
because it was able to protect the Parks.
Yes, the Parks kept a gun for their personal safety, and they kept it close to their bedroom.
Now, you can't tell the court who opened that safe, can you?
No, I can't.
And you can't testify as to how exactly someone actually was able to get the weapon that day, can you?
No, I don't know how the weapon was obtained.
So you don't know who took the weapon out?
No, all I can tell you is that the facts of today's case are consistent with an accidental shooting.
Now, you said that you find it hard to believe that Jesse Duran could have loaded the weapon, isn't that right?
I did write that in my report, yes.
Now, is it possible for Jesse to have looked up on, say, Google how to load a weapon?
Yes, that's absolutely possible. You can Google how to load a weapon. But as I kind of mentioned earlier, children frequently have a hard time learning the specifics of gun operation, and I find it doubtful that Jesse Duran did know how to load that gun.
That was specifically about normal children, wasn't it?
It was about all children, yes.
It's about, you stated that was about normal children not being able to load a weapon, isn't that correct?
Sure, yes.
Now, Jesse Duran had a fascination with that firearm, didn't he? He knew about the Parks, he researched the Parks gun, isn't that right?
I don't know anything about Jesse Duran conducting research.
Objection, Your Honor. Speculation as to Jesse Duran having some kind of fascination with firearms. They'd have to speculate into the mindset of Jesse in order to determine this.
Let's delete that question. Could you rephrase it or ask it another way
Certainly not.
without that language in it?
Jessie knew a lot about guns, didn't she?
I'm not sure what Jessie knew or did not know about guns.
But Jessie was able to read an owner's manual about a gun, wasn't she?
I don't know anything about Jessie Duran reading an owner's manual of a gun.
A normal child could read an owner's manual, couldn't
I see what you're asking. For everything that I was able to determine, Jessie Duran was 11 years old. She didn't know how to read, and she was fully capable of reading something like an owner's manual for a gun, yes.
You can't tell us if she could or could not load that gun with any professional certainty, can you?
I don't know whether or not she looked into or researched how to load a gun, but like I said before, I find it highly doubtful that an 11-year-old child would know the specifics of loading a gun.
But you cannot tell us if Jessie Duran fired that gun on August 18th, can you?
I can't.
And you can't tell us if she knew how to load the gun.
No, I don't know if she did or not.
And you can't give us any insight into the mindset of Jessie Duran on that morning, can you?
No, I can't.
No further questions, Your Honor.
No request, Your Honor. At this time, I ask that Ms. DeRosa be allowed, Dr. DeRosa be allowed to step down.
Yes.
You're welcome.
And the defense calls Dr. Logan Bashir to the stand. Good afternoon, Dr. Bashir. Could you please introduce yourself to the court?
Hello, my name is Dr. Logan Bashir.
And can you tell us a little bit about what you do for a living?
Well, I have my own consulting firm, and what we do is analyze statements and decide whether or not they're accurate or true.
How are you involved in today's case?
I was hired by Ms. Duran to analyze the statements that Jessie made after the incident on the 18th.
I'd like to talk to you a little bit about your background in analyzing statements like these. Can you tell us where you went to school, Ms. Bashir? Dr. Bashir?
Of course. I went for my undergrad at Oklahoma University. I got my bachelor's and master's there in psychology. After that, I decided to continue and get a law degree at Colorado. And then I decided to continue my education in the psychology field specifically and get my PhD at Stanford, specifically in false confessions.
Well, I'd like to talk to you a little bit more about your consulting firm. What exactly is it that you do there?
Well, I'm a professor at Arizona State at the moment, and I like to have my consulting firm on the side. So what we do is we analyze statements, and we decide whether or not they are true or false, basically.
What sort of evidence do you need to do this analysis?
Well, normally we need the statement itself, and we need statements of from the individuals who were either there during the event or performed the investigation.
Well, once you have all that evidence, what do you do?
Normally we look through the statement itself and at the surrounding documents for certain hallmarks or things that have been proven over time in different studies to indicate that a false confession may be present.
Is that what you did in today's case?
Yes.
Can you tell us what evidence you looked at pertaining to Jessie Duran's statement?
Well, I was supplied with the statement, and I was also supplied with the statement of Hailey and Duran and Mr. Williams. He was actually the leading police officer on the scene of the crime.
And was that evidence sufficient to go into your research with?
Yes.
Did you use your normal methods in this case?
Of course.
Did you apply them reliably, Dr. Bashir?
Yes.
Well, I'd like to talk to you a little bit about that statement. Did you find any of those hallmarks that you were looking for?
In this particular...
Objection, Your Honor. At this point, I am going to make the claim that opposing counsel has not laid the proper foundation for Dr. Bashir to be considered an expert, and she's about to go into testimony that only an expert should be allowed to.
And what is it that you think she's lacking in
Your
the
Honor,
foundation?
Excuse me, Your Honor. I do not believe that she has successfully demonstrated that she used reliable principles and methods. We haven't heard about any of the specific studies that we used. We haven't heard about any specific methods that have been subjected to any scientific variability. We haven't heard any of the specifics of her methods. It's not enough for an expert to come up and say that she relied methods. We have to hear about them.
May I respond, Your Honor? Dr. Bashir just stated that she looked at all the evidence, she looked at the written statement, and she looked at 2 affidavits to see the circumstances that surrounded the written statement, and she specifically looked at these things for hallmarks that are tested in her field that are normal for people to look for when they look for false confession, and that's exactly what she did. She looked at the documents and looked for the hallmarks. That's her methods. That's her evidence. We laid the foundation.
If I may, Your Honor.
Yes.
As we just talked about, it's very easy to make a Google search. I could Google the hallmarks of a false confession, examine any document, see if they were present. It doesn't make me an expert, and it certainly doesn't mean that I should be allowed to talk about those conclusions in a court.
I think we ought to resolve this by asking you to go into a little more detail about what she did in this case with this person.
Yes.
And explain in some detail what each test was. And then we'll see where we go.
Dr. Bashir, how do you look for these hallmarks?
Well, what we do is we have multiple studies. We look at statements that are brought to us, and the way that we test whether or not they're false confessions is with the evolution of DNA evidence, we can figure out whether or not a person was actually guilty, and the ones that were not, of course, the confessions they made were false. Then we can look at the surrounding evidence of these confessions and figure out what factors played into this, and that was the way that these factors were originally developed. What we do in our specific field is look for these factors within the statements that were given and provided, along with the affidavits, because a lot of the factors have to deal with the surrounding events that were occurred during the time of the writing of the statement.
All right, Dr. Bashir, well, I'd like to talk to you about those factors. Did you find any of the factors that you commonly use in your field in today's case?
Your Honor, once again, I'm going to renew my objection as to whether or not she used reliable principles and methods. All we really just heard is that studies have been done about hallmarks. Once again, I could look those studies up. There's nothing that really
I
qualifies.
think you do have enough to form a basis for your cross-examination, and I suggest that's the way you should approach this.
Yes, Your Honor.
Let's hear what she has to say, and then you can challenge that.
Yes, Your Honor.
So once again, Dr. Bashir, did you find any of those hallmarks in today's case?
Yes, actually, in today's case, we found two of these hallmarks, juvenile status and minimization.
Can you briefly tell us what juvenile status means?
Well, it's exactly what it sounds like. It basically means the individual who wrote this statement was under the age of 18.
What about minimization? What is that?
Minimization is when an individual writes a statement and they do take blame for the incident, but they make sure that they write down how it was an accident. They basically minimize their blame.
Dr. Bashir, in this circumstance, is finding those two hallmarks sufficient to determine that Jesse's confession was false?
In today's case, I couldn't find to any degree of scientific certainty that Jesse's confession was false.
Thank you, Dr. Bashir. Pass the witness, Your Honor.
Cross, Your Honor. May I proceed?
Yes.
Hello, Dr. Bashir.
Hello.
First, I'd like to specifically clarify. You were employed by Mr. Rand to try to ascertain whether or not police had forced Jesse to make a confession of guilt.
Yes, that was the reason Mr. Rand hired me.
Okay. Now, I'd like to get into that hiring process. Initially, when Mr. Rand hired you, she was hiring you to possibly fight criminal proceedings that the district attorney might have brought up against Jesse Durant.
Yes, that was my initial purpose when I was analyzing the statement.
At that time, you worked 160 hours in preparation for a possible criminal case,
Yes.
which means that out of your total 200 hours, you only worked 40 hours of preparation preparing for a civil case.
Yes, most of my work was still relevant in figuring out whether or not these hallmarks were present in the statement. That doesn't really change based off of what trial it's in.
Certainly, so you heavily relied upon those 160 hours of initial analysis.
Along with the further 40, yes.
Now, Dr. Bashir, you initially began working with Mr. Rand in 2010, correct?
Yes.
But you didn't work with her continuously up until today's court, did you?
No, there was a period of time between charges.
That's right. In September of 2010, Mr. Rand actually let go of your services, didn't you?
Yes, they were no longer pursuing criminal charges against Jesse Durant.
And she did not reopen your retainer until April of 2011.
Yes.
So that means that those 160 hours that you relied upon, as you said heavily, had been sitting cold for half of a year, or a little more than.
Yes.
Okay. Now, Dr. DeRosa, I'd like to go into your payment. You're being paid by Ms. Duran in today's case, aren't you?
Yes, I'm being compensated for my time.
Absolutely. As an expert witness, you're compensated for your time, correct?
Yes.
Now, you worked 200 hours for the Durans in preparing your report, didn't you?
Yes, the 160 from the earlier trial, as you mentioned, and then the other 40 hours in preparation for this trial.
And then you worked an additional 20 hours preparing specifically to testify, didn't you?
Yes.
Now, Dr. DeRosa, in sum, Hayden Duran is paying you for those 220 hours $88,000.
Yes,
isn't she?
this is my standard consulting fee that we expect at the firm.
So that's a yes, $88,000 for representing Ms. Duran.
Yes.
Okay. Now, Dr. Bashir, I'd like to go into the methodology that you used to compile a report. You'd agree that it's difficult to ascertain whether or not a confession is false under the best of circumstances, wouldn't you?
Yes.
So you'd also say that diligence is required in figuring out whether or not a confession can be false.
That's why I had to work 200 hours in this specific case alone.
But Dr. Bashir, you didn't review all of the witness affidavits or exhibits for today's trial, did you?
No, I asked for the ones that I felt were necessary. Hayden Duran's affidavit, along with the leading police officer's affidavit.
In fact, you didn't even review Jesse Duran's deposition, did you?
No.
You don't know what Jesse Duran's deposition says at all,
No, I do not.
even though you're here talking today about Jesse Duran's confession.
Yes.
Now, you did want to speak with Jesse Duran, didn't you?
Yes.
But Hayden Duran told you that that didn't really make much sense.
That's what his attorney said. Hayden Duran did not say that.
So Hayden Duran, through his attorneys, communicated to you that it didn't make sense.
Yes.
He communicated to you that it didn't make sense to talk to the person you were trying to analyze.
Unfortunately, this is a problem that we sometimes have when it comes to confessions in our field. So we learn to work with the statements that we are given, and I was still provided with the statement itself, which I could analyze for the hallmarks. That was the most important piece of evidence.
Directing you back to my question, Dr. Bashir, even though Hayden Duran had hired you to try to figure out whether or not this confession was false, she would not let you speak to her daughter.
No.
Now, Dr. Bashir, you identified a lot of the hallmarks of a false confession, and I'd like to go through them one by one, but there's a lot, so I hope you don't mind if I go through them one by one.
Okay.
Now, one of the hallmarks of a false confession is an intellectual or cognitive disability, correct?
Yes, that is one of them.
You found no evidence that Jesse Duran suffers from an intellectual or cognitive disability.
No, we found no evidence of that.
Another one of the major factors for a false confession is police interrogation, specifically lengthy police interrogation.
Yep.
You found no evidence that the police interrogated for a long amount of time Jesse Duran.
No, we didn't find any evidence of this.
Another major factor in a false confession is whether or not someone has been isolated by the police.
Yes.
You found no evidence that Jesse Duran was isolated by the police.
Not in the typical sense, no.
She was not in a familiar or threatening location, was she?
No.
There were only a few police officers present at the scene,
From my understanding, there were only 2.
and it does not appear that those officers coerced Jesse.
Yes.
So based on the material that you did review, Officer Williams did nothing to coerce Jesse's confession.
Yes.
Furthermore, you talked a little bit in your report about Officer Williams' tactics, but you have no way of showing whether or not Officer Williams' tactics overall were coercive.
No, I only have this statement to go by. That's why we only found evidence of minimization and juvenile status.
Dr. Bashir, overall, you are unable to say with any degree of certainty that in regards to Jesse stating that this incident was an accident, you have no way of telling whether or not that's false.
No, I was not able to find to any scientific degree of certainty that the confession was false.
Dr. Bashir, overall, you have no concrete way of knowing anything that happened on August 18, 2010 in the Parks home.
No, other than what I was given.
So that's a yes to my question.
Yes.
No further questions.
Redirect, Your Honor.
Yes.
Dr. Bashir, I would just like to clarify a little bit. Do you believe that the confession Jesse gave on August 18, 2010 was false?
No.
All right, then what did Jesse admit to?
Jesse admitted to the fact that what happened that day was an accident.
Thank you. No further questions, Your Honor.
I beg the court's indulgence for just 1 second.
Yes, sir.
No further questions, Your Honor.
Thank you.
May Dr. Bashir step down?
Yes, you-
And
Thank
with
you
that,
very much.
the defense rests its case in chief. May we take a brief 5-minute recess?
How long?
5 minutes, Your Honor.
We can do more than that if you want. You guys have to prepare your closing arguments.
Would y'all like 10?
You need more than 5, you need 10.
10.
Okay, thank you. tell the client whether they are lying or not in a written statement? I mean, that's off the wall. I mean, I wouldn't even have let her tell her name. I would have thrown her out of the court. Very good witness, but with a bogus subject.
Yeah.
Picking the field, you're gonna have your three experts testify, and it's pretty important. And then I think they sort of squander. their-
Thinking the same thing.
Yeah. That's not something you can grade them on. Maybe you can, I guess you can. But that might go.
Definitely good feedback for them.
It's, something the coach really should be responsible for. And I don't wanna make that criticism in front of her. I don't think that's appropriate. Because she was given an impossible assignment and told to run with it.
Definitely.
Okay. Go ahead.
I'm coming outside. I'm coming out here.
Halfway around the building. You know the way that you came in, like over there? Over there. Yeah, if you go, like, you go down and then this way, and then turn another way. Yeah, it's good that we got 10 minutes. The thought
Yeah.
is,
Please sit down. Well, we're in good shape on time. We have 1 hour. We can discuss a lot of things. But we have 9 minutes each for each side for the closing argument. This is what a trial comes down to, ladies and gentlemen. There's nothing that's going to influence a jury any more than these next 9 minutes. And you who are the people that are presenting those arguments have that responsibility, and your whole team is rooting for you. But don't try to be Clarence Darrow or anyone else. Be yourself. Relax, enjoy the moment, take advantage of your opportunity here. This may be your springboard to your legal career. You never know. You never know. And you may think up some arguments along the way, listening to your opponent, that will send you soaring to new heights. So, with that preface, it's now 5 o'clock, we have until 6 o'clock, I think. Is that right? Yeah. Okay, so I don't think we're going to be able to find enough constructive criticism to fill that void, because you guys have done very well. Good presenters. So why don't we, without further ado, begin with the closing arguments for the plaintiff.
May I proceed, Your Honor?
Yes.
Ladies and gentlemen, when you look at Jessie Duran, you don't see a monster. What you see is a little girl. However, you have to look underneath the surface, towards her actions, towards her soul, and what she is. We have proven today, through people who knew Jessie, through people who were actually interacting with her throughout her life, of what she was transformed into. Through the violent media, through her preponderance, due to her own abilities as a psychopath, of what exactly a monster is. It's not Frankenstein taking the little girl and drowning her. It is Jessie Duran, who pointed the gun at her friend, who looked in her eyes, and who pulled the trigger. Now, we have proven through three witnesses the obsession, the deception, and the intention that Jessie Duran had that day on the morning of August 18, 2010. Now, what you have to question is, what exactly has the defense proved? Their entire theory rests on that this is an accident. However, if we prove to you that Jessie, one, hurt and was the results, the proximate cause of Sidney Park's death, and two, that she meant to pull the trigger, that her psychopathy, her willingness to get that thrill through any means necessary was the reasoning behind that, then the scales of justice are going to tip in our favor. Now, let's talk about the burden that each side has. We as a plaintiff have to prove to you by preponderance of the evidence that our claim that we are asserting that Jessie Duran did willfully and maliciously pull that trigger are true. Now, that is not a large burden. I'll be honest with you, members of the jury. I'm sure the judge is going to brief you after the trial on what exactly that means, but I'll explain it real quickly right now. It means that when you have the scales of justice, all that is needed is a grain in our favor. And that is what is going to make it so that Hailey Duran is liable. Let's go through the points that the defense thinks is going to win this trial for them and show their fallacy. First, you heard from Logan Bashir. Now, Logan Bashir is going to try, the defense is going to try and say that Logan Bashir proved that it was an accident, that the confession proves it was just an accident. I mean, what else could it have been? It was an 11-year-old girl. However, remember that that is only part of the problem. She did not want to, Logan Bashir did not speak to the validity of whether it was or was not an accident. She spoke to the validity of whether or not the confession was true or false. That has nothing to do with the matter at hand today. And remember, couples, the only person who can speak to the mindset of Jessie Duran, that she had deception, that she was able to fool those around her because of her psychopathy. Now, you also heard from her neighbor, Terry Chapin, And Terry Chapin gave you a very nice story of walking into that room, of seeing that little girl with the body next to her, and seeing her just break down. However, question, was this a little girl, or was this a monster? Was she really feeling those emotions, or was, as Mr. Chapin pointed out, that just a ploy? Was that more manipulation? Because remember, you can't trust anything at face value from a psychopath. The face that Terry Chapin saw was not the face of a little girl. It was the face of a monster underneath it that performed those actions that day. Finally, you heard from Ashta Rosa. Now, Ashta Rosa recognized that she could not tell you whether or not Jesse Dran did these actions. She can't tell you if it was an accident. She can't tell you if Jesse Dran had the ability to load that weapon, to fire that weapon. They have not proven their burden as a defense that this was simply an accident. However, our three witnesses have given you various warrants as to why it was not. Now, let's start with the beginning. Andy Park, a grieving father who just wanted his little girl to have justice in this courtroom today. To have the innocence, to have her faith in justice and his faith in rightness restored even after the charges were dropped against Jesse Dran. However, he will tell you that he's the only one in this court today who can testify to who Jesse Dran was as a person. That he saw the obsession with violence. That he saw emerging in her a monster. That was thriving on violent video games. That was thriving on her charge towards greater violence in her life to fill her need as an emerging psychopath, which we got from Dr. Couples. Dr. Couples came up here and he explained exactly what a psychopath is, and that Jesse Dran met every definition of this, that she was a thrill seeker, and that she could only get these thrills through more and more violence, as it grew more gratuitous, from drowning a cat, to throwing rocks at cars, to killing her best friend. Now, granted, the only person who can really testify in this court today what happened that day is Jesse Dran, but Jesse Dran knew that she could not lie to you well enough, ladies and gentlemen. And that is why she pleaded the fifth. That is why she's not here today to show remorse, because as Dr. Couple says, she is remorseless. She is a psychopath who is willing to do anything to get her thrills and was not ashamed of that fact. And finally, you're presented with Ms. Sebastian. And Ms. Sebastian gave you evidence that Jesse Dran looked at her best friend in the eye, that she raised the gun, and that she, with no remorse, pulled the trigger. She was constantly evolving, constantly looking for more thrills. And at the end of this day, ladies and gentlemen, jury, what you have to ask is, was real enough for Jesse Dran? No further.
Thank you.